Good evening and welcome to Empower You. Thank you for coming out tonight, and we're glad to have those of you online with us tonight also. I just want to go over a few things. We will be passing a bucket later. Any donations that you feel like you would like to give, we appreciate. We run by donations only. And also we will have some questions and answers at the end of our presentation, and I just ask that if you have a question, to raise your hand so we can bring a microphone to you so that everyone in the studio as well as those online can hear. Also, those online, you can submit a question as well. I just want to go over our classes that we have remaining for this year. Believe it or not, we're coming to an end. We have a class next Thursday called Painting with a Twist. If you haven't signed up for that yet, or if you haven't done it yet, it's a real fun thing to do. Everybody gets to paint their own picture. You have an instructor who shows you step by step what to do. And I've done it twice, and the picture actually did look like the instructor's, not as good. But it took me past stick figures, which was where my ability was. So it might be something you want to try. On April 24th, we have the Beverly Hills Supper Club Fire. Most of you here probably remember that. The gentleman that will be speaking that night was one of the people that was there that night. He was the head maitre d', and he almost didn't make it out of the fire. And he'll be telling you about his experience with that, as well as some people say it's a conspiracy. He says it is not, and he'll be telling us about that. Then on April 26th, we have In the Garden with Ron Wilson, which is very timely. I'm sure all of you here know about Ron Wilson, but he's going to be coming in and talking to us about our gardens, which all of us will be starting right about that time. So that's another class you might want to try and make. That's actually our last class, except for May 2nd. We don't really consider that a class, but that's our ending event where we will be having food, asking everybody to bring a dish. And we'll have speakers that night. Rocky Boyman will be here, Chris Smitherman, Chris Monzel. I'm not sure who all, but it'll be a big star cast, I'm sure. So anyway, next I'd like to introduce you to Nita Thomas, our Executive Director.
Good evening. I want to welcome everyone here tonight. I'd like to tell you a little about our speaker. Stephen M. is a native of Cincinnati and earned his law degree from Georgetown University in Washington, D.C. He has been in private practice since 1987, beginning his career with the Cincinnati firm of Taft, Stettonist, and Hollister. Before joining the Finney Law Firm in 2016, Steve was a partner at Katz, Greenberger, and Norton in Cincinnati, where he was in charge of the firm's labor and employment law practice. Steve is a trial lawyer who has conducted more than 60 jury trials in numerous state and federal courts involving discrimination, harassments, and other employment issues. He has also won several cases at the highest appellate levels that have helped to shape the current state of employment law. Steve lives in the Mount Washington section of Cincinnati and has 3 children. So as you can tell from his bio, he's going to be a very well experienced speaker on the subject tonight. And we'd like him to pull out a ticket so somebody can win the door prize. You want to pull one out, Steve? You guys have a pretty good chance of winning tonight, you know. Yeah, or I can, it doesn't matter. Okay. 126. Okay, you won it. Here, yay. And what's your name?
Annette.
Annette, well, welcome,
Yeah.
Annette. Is
Thank
this your
you.
first time?
Second time.
Well, good, see?
Good, thank you.
Oh.
That's the right number, right?
Yes.
I don't want to cheat.
Oh, Annette, no, you're
Thank
not.
you.
You're not cheating. Okay, and with that, we'll let Steve take over.
Thank you, Nita, and good evening, everyone. Thank you for coming here tonight. Welcome to everyone here in the hall. And it's my understanding that we have some viewers online as well. So they told me to try to look at the camera. I think that's the camera. So thank you all for being here tonight. We're going to be discussing a topic that is, I think it's fair to say, very timely. We're going to be talking about Hollywood's sexual harassment problem, the Me Too movement, and what these kind of remarkable developments of the last 6 months since the Harvey Weinstein revelations, what they mean for our country, what they mean for our workplaces, because they're going to have and are having some very implications on all of us. So tonight's topic, as you see, is what businesses and employees can learn from Hollywood's sexual harassment problem. This next slide, sexual harassment, a brief history in pictures. When I put this slide together, I didn't think it through clearly. If you see this slide, you might think you're about to see a bunch of pictures of people being sexually harassed. But that's not what you're about to see. First thing you're about to see, many, perhaps most, maybe even all of you recognize the people in this photograph. This is from The Greatest Show Ever, called Mad Men. And if you've ever seen Mad Men, you know it takes place in the 1950s and 60s primarily. And the reason this slide is here is because it depicts I think pretty accurately, a workplace from the 50s and 60s in regard to sexual politics in the workplace in a very accurate manner. And if you've ever seen the show, you know that there's a lot of really, really inappropriate behavior that takes place in the storyline of this program. And I bring this up because it's really interesting and kind of astonishing in a way to know now that all of the harassment, all of the inappropriate touching, all of the really gross and lewd humor and blue language and so forth that women were subjected to as depicted in the show was completely legal. In other words, there were no legal remedies for sexual harassment in the workplace in the 1950s and 1960s. Now think about that for a minute. Among other things, that meant that a boss, a supervisor, a manager, could fire an employee for refusing to sleep with him. Let me repeat that. An employee could be fired for refusing to sleep with their boss without any legal consequences or repercussions. There's nothing that could be done about it. That was the reality of the workplaces all over the country in the 1950s and 1960s. There we go. Can anybody tell me what's depicted in this slide? Anybody happen to know? I have very poor eyesight, by the way, so if you're raising your hand and I don't see you, raise it a little higher. Yes, very good, sir. This is President Lyndon Johnson in 1964, signing the Civil Rights Act of 1964. The reason this slide is in here is because this is the legislation that would provide, ultimately, about 10 to 15 years later, would provide the legal underpinning for legal claims of sexual harassment. Now, I assure you, none of the people depicted in this photograph realized it at the time. And you may notice that every single person in the photograph is a male. There's not one female in this photograph of this landmark legislation being signed. But this is the legislation that, the federal legislation that illegalized various forms of discrimination in the workplace. It said you can't discriminate on the basis of race or color or religion or sex or national origin. And the language in the statute prohibiting discrimination on the basis of sex would ultimately, many years afterwards, would lead to the modern law of sexual harassment that we now understand. Next we have, well, this actually is a picture of somebody being sexually harassed. Take back what I said before. Not a particularly lewd picture, but this is from, there was a case called Williams versus Saxby in 1976, decided in 1976. And this was the first case in the American judicial system that recognized a claim for sexual harassment, that where a worker was able to claim that discrimination, or excuse me, that harassment that was sexually based could constitute and did constitute a violation of the Civil Rights Act as a form of sex discrimination. And Williams versus Saxby involved an employee of the US Justice Department, of all things, who was being harassed by her supervisor, who was making all kinds of romantic and sexual advances to her that were not welcome. And when she rejected those advances, he retaliated against her and ultimately dismissed her from her position. And the court recognized for the first time a claim of what's called quid pro quo sexual harassment, which means this for that. Quid pro quo harassment means if you do this for me, then I'll do this for you. Or if you don't do this to me, then I'll do this to you. And so it took 12 years from 1964 to 1976 before the court first recognized a claim like this. This is the United States Supreme Court from 1986. You probably recognize at least one or two of the faces on the court there. Upper right hand, in the top row is Justice Scalia. Top row on the left is Justice Sandra O'Connor, first female justice on the Supreme Court. On the bottom row, on the left-hand side, you've got Thurgood Marshall, the first African-American justice on the Supreme Court. But this case, Meritor Savings Bank versus Vinson, recognized a different kind of sexual harassment claim, not a quid pro quo, you better sleep with me or else type of claim, but rather what's called a hostile work environment claim. Hostile work environment meaning that someone, not that necessarily someone was fired or demoted or denied advancement, but rather was subjected to a work environment that was hostile on the basis of the person's gender. Because they were female, they were subjected to a hostile environment. And we're going to talk a lot about that in a little bit. This is, I'm sure most of you recognize these two individuals. On the left is Clarence Thomas, on the right is Anita Hill. In 1991, President H.W. Bush, George H.W. Bush, nominated Mr. Thomas to be a Supreme Court justice. And at that time, Anita Hill came forward and accused Mr. Thomas of sexually harassing her, requiring her to submit to a hostile work environment when she worked for him. And this really gripped the nation's attention in 1991 and really brought to the forefront in a way that hadn't happened before, the issue of sexual harassment. Mr. Thomas would go on to be confirmed by a very narrow margin to the Supreme Court. This is a little bit less serious of a photograph, but I'm sure most, if not all of you, recognize that as Michael Scott. Michael Scott was the general manager of the Dunder Mifflin Paper Company on on the show The Office, which ran from 2005 to 2013. By the way, my own father is basically Michael Scott. He too was the general manager of a small Midwestern paper company. And just like Michael Scott, my dad just didn't have any kind of clue as to how to run an office. Bless his heart. My dad was raised in the 1950s, and he never really left the 1950s. He got older, but his mind stayed in the 1950s. And although he wasn't malicious or he didn't victimize anyone, he had no clue as to what was appropriate or inappropriate in the workplace. In his mind, it was always still 1955. And just like Michael Scott, he would say things at work that would make you cringe. And the interesting thing about this, though, is that we all kind of like Michael Scott, right? We all, if you watched the show, even though he was kind of clueless and he would inadvertently say things that would make you cringe, there was no malice in it, right? And so at the time this show was airing and the time it was popular, a lot of people had the idea that sexual harassment was kind of funny and it was something to a source of humor. And then came this guy. This is the infamous Harvey Weinstein, the now disgraced Harvey Weinstein, who it was really the exposition of his crimes and his acts of sexual assault and sexual harassment and even rape that spawned the Me Too movement. And the disclosures about Mr. Weinstein's misbehavior came in, I think, the August, September, October timeframe. And it was as a result of those disclosures that all of a sudden you had this avalanche of allegations and revelations about numerous people in Hollywood, in business, in politics. For a while, it seemed like every time you picked up the newspaper, there was a new revelation about a new perpetrator of sexual harassment. And one after another, all of these people were brought down as a result of these allegations. And here's just a few of them. Well, first, this is a slide of a woman that's probably not familiar to you. Her name is Tarana Burke. And Tarana Burke actually coined the Me Too movement in 2007. But it did not become well known until this woman, an actress named Alyssa Milano, began encouraging on October 15 of 2017, October 15th of last year, she urged all of those who had been victimized by sexual assault or sexual harassment to post #MeToo on Twitter. And she did that on October 15 of 2017. And immediately this touched a nerve and spawned a movement that would bring down countless figures in politics, business, Hollywood, etc. Within a week, #MeToo was in 1.7 million tweets. 85 countries had at least 1,000 #MeToo tweets. Facebook had more than 12 million posts, comments, and reactions regarding #MeToo in less than 24 hours by 4.7 million users. 45% of Facebook users, almost half in the United States, had a friend who posted #MeToo. So it really, as I say, touched a nerve and opened the floodgates to accusations that had been kept quiet for a long, long time. And I've just got a few pictures here of some of the people who were brought down. All of these people that I'm going to show you, by the way, are not individuals about whom there's any doubt that they committed the acts in question. All of these people either admitted to the wrongdoing or resigned because of their inappropriate behavior. There's the comedian Louis C.K., the actor Kevin Spacey, the PBS talk show host Charlie Rose. This name might not be familiar to you. This is a gentleman named Michael Oreskes, who was a high-ranking executive at National Public Radio, who, you know, an organization that you might think would have a pretty progressive attitude about women's rights issues and gender equality. But he had to resign amidst numerous allegations of inappropriate conduct toward women. This is the one that really got me, Garrison Keillor. Garrison Keillor, who for decades had been the host of the Prairie Home Companion on public radio. You know, if you had asked me to make a list of all the people who I think might be guilty of sexual harassment, I'd probably go through a lot of names before I got to Garrison Keillor's name. But Garrison Keillor had to resign his position as the host of the Prairie Home Companion based on allegations made against him of sexual harassment. And I thought, where will it end at this point? Were we going to hear that Mr. Rogers, Mr. Rogers' neighborhood was getting handsy with the production assistants, or Captain Kangaroo? I didn't know where it would end at this point. It affected not just Hollywood and the entertainment industry, but also politics and some very, again, people who you would think, you know, might have some sensitivity to these issues. Al Franken, a very liberal member of Congress, had to resign his seat. John Conyers is an icon of the civil rights era. Rosa Parks worked for John Conyers for 23 years. That's how influential John Conyers was in the history of civil rights. And yet he too was brought down and forced to resign his seat as a result of allegations of sexual harassments by his female workers. This person's probably not familiar to you, but he was a judge on the Ninth Circuit Court of Appeals, one of the highest appellate courts in the country, just below the United States Supreme Court. His name is Alex Kozinski. Judge Kozinski had to resign from the Ninth Circuit Court of Appeals because of multiple allegations of sexual harassment made against him. Now, keep in mind that the hashtag #MeToo movement was born October 15 of 2017. This Time magazine cover is just a little over 2 months later, and it's announcing the Person of the Year. And this movement was so widespread and set off such a powder keg and was so influential that just 2.5 months later, the Person of the Year was, by Time magazine's lights, the Silence Breakers. These are individuals who had come forward with breaking their silence about harassment that they had experienced or observed or encountered in their professional careers. So it obviously was a movement of enormous impact in our country, and made a huge impact in just a very short period of time. So let's talk about some lessons from Harvey Weinstein and the hashtag #MeToo movement. The first lesson, I think, is that sexual harassment is not a relic of the Mad Men era. It was the first slide that I showed, remember, in the history of the pictorial history of sexual harassment. There is a tendency, I think, to believe that was something that had been left behind in the 1950s and 1960s. I don't think there can be any doubt at this point that sexual harassment is not something that is a relic of a bygone era. Another lesson, I think, is that sexual harassment has been significantly underreported in our nation's history. When you think of all of the individuals who posted #MeToo, all of the individuals that came forward in the wake of October 15 of 2017, only a tiny, tiny, tiny percentage of those find their way into the court system or into a formal allegation of harassment. So this is something that has been kind of bottled up through much of our nation's history, and victims of sexual harassment tend to be very reluctant to come forward. I think we can say that without fear of contradiction when we look at what has happened since the revelations about Harvey Weinstein. Sexual harassment can be committed by anyone. What do I mean by that? Well, note that a lot of the figures that were brought down in the wake of the Weinstein allegations and the Me Too movement, a lot of those people like Al Franken, John Conyers, the head of NPR, Garrison Keillor, Charlie Rose. I mean, these are people who, again, you might expect to have some sympathy for issues of women's rights and gender equality. These are people who you might think would be sensitive to those kinds of matters. Before Weinstein was brought down, Weinstein himself was a very big contributor to, an enormous contributor to Democratic presidential candidates who are often viewed as being more sensitive to women's issues than Republican candidates. But before Weinstein, you had all these allegations against Bill O'Reilly at Fox News, Roger Ailes, the president of Fox News, people of that political ilk. And you might have said, well, you can kind of understand how, Fox News might have a sexual harassment problem. But what we discovered in the wake of the Weinstein allegations is that this is not a matter of politics, that people on the left, as well as people on the right, people in the middle, sexual harassment can come from anyone, regardless of what their political beliefs or views might be, regardless of how sensitive you might have expected them to be about those issues. More than anything, sexual harassment is about power. And I say that because, harassment is something that is impossible in the absence of some kind of power dynamic. Notice that all of the people that we were looking at earlier are people of immense power, people of immense influence. And there's a reason for that. There's a reason for that. If you don't have any power in the workplace, if you're just a low-level employee of an employer, you can't commit sexual harassment. On the other hand, if you're, or I should say, you can only commit sexual harassment if you have the power of the employer behind you. And the reason that high-ranking executives and other powerful people can get away with sexual harassment is because they have power over the people that are below them. And when they misuse that power, it can have devastating consequences. Some less well-known facts about sexual harassment. First of all, it can be committed by people of either gender. It's not limited to male on female behavior. It does happen in the reverse, not nearly as much as it does when men on women, but I can tell you even back in the early 1990s, the first sexual harassment case I ever took to trial involved a male employee who was sexually harassed by a female supervisor. He worked as a maintenance supervisor at an apartment complex. And the property manager made a pass at him, and he rejected her sexual advance. 30 days later, he was fired. He alleged that he was fired because he rejected her sexual advances. The jury found in his favor. You know, she denied making the advances to him. She denied that that was the reason for the firing, but we were able to prove the case because the reasons that they gave for firing him didn't make sense, and they didn't hold up, and they were obviously false and were being advanced as a pretext to cover up the real reason for his termination. And so the jury believed my client, and the jury was able to infer from the fact that they lied about the reason for his firing. We're able to infer from that that the real reason must be that he turned down her sexual advances. So it can occur in reverse, and it can occur from either gender. It also doesn't depend on sexual orientation, and this is kind of important. The United States Supreme Court ruled 2 decades ago in a case called On Call versus Sundowner Offshore Services that male-on-male sexual harassment was a violation of Title VII and was sexual harassment under the law. So it does not depend on orientation. Employers can be liable for harassment committed against one of its employees by someone who is not an employee. What I mean by that, for instance, if you are an employer and you have an employee who is being harassed by someone who's not your employee, let's say you've got a vendor that comes into your workplace on a regular basis, or you've got a customer that's at your workplace on a regular basis. You've got a supplier, you've got whoever, the postman or whatever, delivering the mail every day. If they're harassing one of your employees and you as an employer become aware of it, you have a duty to address that situation, even if the harassment is not being committed by one of your own employees. The employers can be liable for harassment that's committed away from the workplace and outside of business hours. Employers sometimes mistakenly believe that they're only responsible for what takes place inside their building. Not so. If the harassment can take place on a business trip, at a company picnic, at in a hotel room, while visiting a customer, whatever, it doesn't matter. If your employee is being sexually harassed and you as an employer become aware of it, you've got a duty to address that situation. So let's first of all get down to the basics and ask ourselves, what actually is sexual harassment? There's a difference between what the legal system considers sexual harassment and what is commonly referred to as sexual harassment on a day-to-day basis. We've probably all heard at one time or another somebody say something like this: "Hey, that's sexual harassment." Maybe often said in a joking manner, but if you're in a workplace and you see somebody putting their arm around somebody else, or putting their hand on somebody's shoulder, or making a vaguely off-color joke, somebody may say, "Hey, you can't do that," or "You can't say that, that's sexual harassment." Well, not necessarily. What the law means as sexual harassment is something different than what you and I may mean in ordinary conversation. Not every time somebody says something inappropriate or touches somebody on the shoulder, that's not always sexual harassment. So let's talk about the difference. What's the legal definition of sexual harassment? Let's start there. And this is going to sound a little dry, but let's at least go through it for a couple minutes. Well, sexual harassment is unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature when one of the next three things, I'm going to use the laser pointer here. Maybe I'm not. There we go. When one of these three things exists. First, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. So, an employer says, hey, I want you to go out to dinner with me tonight so we can discuss your promotion. In other words, if you don't go to dinner with me, you're not going to get a promotion. That is a form of sexual harassment. Number two, submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting such individual. Those first two bullet points are what we referred to before as quid pro quo sexual harassment. You do this and you'll get this. If you don't do this, then you won't get this. And then the last one is what we call hostile environment sexual harassment, where such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. This is where the phrase hostile work environment comes from. So if there's verbal or physical conduct of a sexual nature taking place in the workplace, and it has the purpose or effect of interfering with somebody's work performance or creating a hostile work environment, it is illegal and it's then considered sexual harassment. There are two types of sexual harassment, as we've talked about: quid pro quo, this for that, and hostile work environment. Conduct is not sexual harassment if only one of those was supposed to come up at a time. First of all, in a hostile work environment case, conduct is not sexual harassment if it is not severe or pervasive. Okay, so what I was saying before about, the occasional touch on the shoulder, the occasional lewd joke, the inappropriate image that might be displayed in the workplace, in order for that to constitute legal sexual harassment, it has to be severe or pervasive, and we'll talk about what that means. If it's not severe or pervasive, if it's just here or there, occasional, not particularly severe, the law is not going to consider it sexual harassment. Also, if the conduct is not unwelcome, okay, in order for something to be sexual harassment, it's kind of elementary, but it's important to recognize this. Something is not sexual harassment if it's not unwelcome, okay? If someone is making sexual advances to an employee, even if you're talking about a boss and a subordinate, if the subordinate is welcoming of the advances, then it's not sexual harassment. It's only when it's unwelcome that the law concerns itself with it. So we talked about the phrase severe or pervasive. Remember, for something to be sexual harassment or to create a hostile work environment, it has to be severe or pervasive. So when is conduct sufficiently severe or pervasive to constitute sexual harassment? First of all, it's important that Title VII of the Civil Rights Act of 1964, that landmark legislation, courts have said that it's not a civility code. So it's not designed to make sure that nobody ever does anything inappropriate in the workplace. The law understands that there's a certain amount of junk that you put up with in the workplace. And it's not necessarily sexual harassment if it's not severe or pervasive. The conduct must be severe or pervasive. It doesn't have to be both. Even one act, if it's really severe, is going to be sufficient to create a hostile work environment, like a sexual assault. Doesn't have to occur multiple times to create a hostile work environment. Sexual assault, even if it just happens once, is going to be sufficiently severe to create a hostile work environment. Pervasive refers to how frequently the conduct occurs. So as a general rule, the more severe the conduct, the less it takes to create a hostile environment. And physical conduct is going to create a hostile work environment a lot faster than just words or just statements. generally speaking, physical conduct, groping, grabbing, assaults, etc. That's going to create a hostile work environment very soon. If you're talking about inappropriate statements, depending on how severe they have to occur on a more regular basis in order to be considered sufficiently pervasive to violate the law. Now, we talked about the fact that welcome conduct cannot be sexual harassment, right? If a boss asks a subordinate out, and the subordinate has been waiting for the boss to ask him out and is glad that the boss asked him out and to go out in a as mutually consenting adults, there's nothing illegal about that. There's nothing wrong about that. But there are problems. That situation that I just described is rife with difficulty because determining what is unwelcome is a tricky thing when you're talking about a workplace situation. Okay, you're not talking about now two people who just met in a bar who are on equal footing and they're each trying to find somebody that they can hang out with. You're talking about a boss and a subordinate. You're talking about two employees who work in the same company day after day after day. It's not always easy to determine whether or not conduct is welcome. Why is that? First of all, because of the power dynamic that I've just been describing. You know, if person A as a boss says to person B, hey, would you like to go out with me Saturday night? There is inherently pressure on that employee in that situation. Even if the boss doesn't mean to put any pressure on the employee, it's inevitable that the employee is going to feel pressured. He or she may be able to withstand the pressure, but they are going to feel pressure when they're asked that question by their superior at work. Also, human beings are imperfect judges of how their conduct is perceived by others. Believe me, you don't know how many times a boss who ultimately gets sued for sexual harassment will say that he or she thought that it was welcome. That human beings just are not always very good at knowing. Like if a boss asks an employee out to dinner and the employee says yes, the boss is probably going to think, okay, well, this is welcome. He or she wants to go out with me. This is consensual. Well, that human being that's thinking that is an imperfect judge of somebody else's, how somebody is perceiving them. I thought we were friends. The reason I put this in here is because I've heard this, I can't tell you how many times, from a boss who ultimately gets sued by somebody who says that they were being harassed and the boss was just clueless and had no idea. And he will often say, I thought we were friends, which tells you exactly how far wrong people can be in guessing that their conduct is unwelcome. And whenever I hear somebody say that, I say, well, look at this lawsuit here. You see what it says below your name? Does it say friend or does it say defendant? And if it says defendant, then you know it's been cleared up that you got that wrong. The men, without meaning to sound in any way sexist, I think men tend to also be even worse judges than women of how their conduct is perceived by others. I remember hearing the actress Candice Bergen say many years ago that every woman, no matter how beautiful she is insecure about some aspect of her appearance. And every man, no matter how unappealing he may be, feels like he's doing just fine in the looks department. And so it's just way too common for men to mistake how women feel about them or how women feel about advances that they may be making in the workplace. So when is an employer liable for sexual harassment committed by its employee? Now, I don't want to get too deep into the legal weeds here, but you know, harassment is not committed by companies, right? Or corporations. Harassment is committed by people. People harass people. So the question then becomes, well, when are we going to hold a company responsible legally for harassment that's committed by one of its employees? And there are two considerations. First of all, is the harasser a supervisor? Okay. If the harasser or alleged harasser is a supervisor or a manager, that's going to be treated very differently in the law than if it's a low-level employee. And we'll talk about why that is. The other consideration is, did the harassment result in a tangible employment action? Usually that means somebody being fired when we talk about tangible employment action. But it can also mean a demotion, a decision that affects pay or advancement. So these, whether or not a tangible employment action, resulted is a key consideration in determining whether an employer is going to be responsible for the harassment committed by an employee. Harassment committed by a supervisor. Who is a supervisor? Basically, somebody who can hire and fire, okay? Somebody who has authority. Usually it's a salaried employee. Usually it's somebody who has people working under them, and somebody who has the authority to hire them or fire them. Now, the law says that an employer is liable for harassment committed by a supervisor unless two things. There was no tangible employment action, so nobody was fired or demoted or anything like that, and the employer can prove this Farragher-Ellerth affirmative defense that I'll talk about. So the general rule is that if you're a company and you have a supervisor who's committing harassment, you as a company normally are going to be legally responsible for that harassment, legally liable for that harassment, unless these other two things exist, and we'll talk about those. The Farragher-Ellerth affirmative defense. This is an affirmative defense in the law means basically this. Okay, you defendant, you did something wrong, but we're going to let you off the hook if you can prove an affirmative defense. Okay, we're gonna say, all right, there was harassment, somebody did violate the law, but you, the employer, are going to be let off the hook here if you can prove the following things. The first is that the employer exercised reasonable care to prevent and correct harassing behavior, and the employee unreasonably failed to take advantage of the preventative and/or corrective opportunities provided by the employer. What that means is basically this. If you, the employer, can show that you had a policy against sexual harassment, and it's a good policy, and it's a clear policy, and it's clearly communicated to your employees, and all your employees know about it, and it's right there in the handbook, and it's easy to read, and it's in black and white, and you follow it, and the employee doesn't make use of it in spite of all those things, then we're going to let the employer off the hook for harassment in those circumstances. If the employee is told about how to stop sexual harassment, if the employee is given a clear policy, but they don't make use of it, then the employee will not be able to sue the employer successfully for harassment, and the employer can be excused from its liability in those circumstances. Now, what are the minimum steps the employer must take to be able to assert the affirmative defense? If any of you are employers or HR people, this is what you got to do to protect your companies from liability. First of all, you have to communicate a clear and effective sexual harassment policy to all your employees. It should contain an anti-retaliation provision. What that means is you say, we will not retaliate against anybody for coming forward with sexual harassment allegations. Number two, it should have a qualified assurance of confidentiality. What that means is you can't promise your employees that, you know, don't worry, nobody's ever going to know that you came forward with this allegation. You can't promise that because you've got a duty to investigate these allegations. And you can't investigate a sexual harassment allegation without giving some details of what's being alleged. And so, but you should tell your employees, we'll keep this confidential to the extent that's consistent with a good faith investigation of your allegations. And thirdly, there must be a clear reporting procedure in the policy. So that means you got to tell the employee, all right, if you've been sexually harassed or feel like you're being sexually harassed, this is who you report to. And this is how you report it. And you should always have at least 2 different people to report it to, that the employee can report it to. Because, you know, you can't say report it to the president of the company because the president of the company might be the one who's being accused. You can't say report it to HR because HR might be the party that's being accused. So you should always have at least 2 alternatives for the employee to make the report. Second thing the employer must do to avoid liability is promptly, fairly, and thoroughly investigate all complaints. Okay, not just the ones that you think might have merit, not just the ones that you think are serious, not just the ones that come from employees that are good employees or employees that you like. You have to be able to show that you promptly investigate and thoroughly investigate all the complaints that you get. Also have to take effective remedial action when warranted. So not only do you investigate all the complaints, but if a complaint is found to be meritorious or to have merit, then you take some action. What is effective remedial action? Well, we'll talk about that, but it can mean a variety of things. But basically, you need to be able to show that you're taking action to stop the harassment and to protect the victim from further harassment. How to address false allegations. Sometimes false allegations do occur. People are wrongly accused. Make no mistake about it, that happens too. Your sexual harassment policy should address that, but it should address it separately, okay? You shouldn't warn employees against filing sexual harassment allegations by stating in your sexual harassment policy that if you make a false accusation, you can be fired, because that's going to discourage people who are already reluctant to come forward to begin with from coming forward. So you don't want to do that. If you discover, however, that an allegation that was made was clearly false, you can take appropriate steps at that point against the employee, but only do so after the investigation has revealed the allegations to have been false. So we talked about harassment committed by a supervisor. Remember, a company ordinarily is going to be liable for harassment that's committed by its supervisors. What about a coworker? What about 2 people who work together? They're not necessarily in a supervisor-subordinate relationship. You know, they're peers. You know, nobody has the authority over the other. Can the company be held liable for harassment in that circumstance? Well, yes, it can under certain circumstances. The employer can be liable only if, 1, it knew or should have known that the harassment was occurring. Okay, so if this never filtered up to management, if no report was made and if nobody observed it, and there's no reason for the company to have known that the harassment was taking place, it's not liable. And the employer can only be held liable if it failed to take prompt and appropriate corrective action. So if the employer knows about the harassment, either because it's been reported or because it observed it or because there was some other reason for the employer to know about it, and it failed to act, okay, it becomes aware that someone's been made to feel uncomfortable, somebody's being victimized, somebody's being subjected to inappropriate touching or language, and it doesn't do anything about it. At that point, the employer can be held liable for the harassment itself. So what is appropriate corrective action? What do I mean by that? Okay, let's say you've got a report of harassment, an investigation is done, there are witnesses, they're credible, you've got some documentation, you as the employer believe that yes, this harassment has in fact taken place. Okay, what do you as an employer have to do about it? What is appropriate corrective action such that the company will be excused from any legal responsibility for the harassment? Well, it means different things in different circumstances. Sometimes it means firing the employee who is found to have committed the harassment, but it can mean lesser things. It can mean reprimanding the employee. It can mean separating the harasser from the victim of the harassment. It can mean monitoring the situation going forward to make sure that the victim isn't subjected to further harassment. But you have to take some, if you find that harassment has in fact occurred, you as an employer do have to take some prompt corrective action that is appropriate. So how to make sure, $64,000 question here, how to make sure that your organization is not the next sexual harassment headline. Make sure you're not one of the pictures on these slides the next time I give this presentation. First of all, do the right thing. And do the right thing because it's the right thing, okay? By do the right thing, I mean, don't commit sexual harassment, don't allow sexual harassment, don't write it off or consider it to be funny or a joke. Do the right thing, but have a sexual harassment policy that's serious and that's effective and that's enforced. But don't do it because your lawyer is telling you to do it. Do it because it's the right thing to do. If you're doing the right thing because your overbearing lawyer is telling you this is what you got to do, you'll do the right thing a lot of the time. You'll do the right thing even most of the time. But if you're doing the right thing because you know it's the right thing, because your organization, because that's the organization that you want to have, if you're doing it because it's the right thing to do, then you'll do it 100% of the time, 10 times out of 10 instead of just 9 times out of 10. Second, create a culture of appropriate workplace interaction. What I mean by that is no locker room talk in the workplace, okay? You know, you don't want to have a workplace where you're saying to your employees, okay, it's okay to do this much, but don't do anything beyond that. And, you know, it's okay to tell inappropriate jokes or display inappropriate images on your computer, but make sure that you don't do it so often that people are offended by it. You don't want to try to create those kind of lines because you're always going to have people crossing those lines. You want to create a culture within your institution, your organization, your employer, your company. Create a culture where it's just not tolerated, okay? If there's a place for locker room talk, in the famous words of Donald Trump's campaign, if there's a place for locker room talk, it's not in the workplace, okay? It's never in the workplace. Not just on Fridays, not, you know, once or twice a year. The workplace is not the place for that kind of talk, period. Create a culture that encourages the reporting of harassment and a zero tolerance for retaliation. Many employers will have a sexual harassment policy, but they'll consider it a bother, okay? Well, our lawyers say we got to have this policy, so, but then as soon as anybody actually comes forward and makes an allegation, they'll roll their eyes and they'll open their book and say, all right, I guess we got to investigate this. What happened? You want to have the exact opposite of that kind of culture. You want to have a culture that encourages the reporting of this behavior because you want to eliminate it from your organization. You don't want it to be a part of your organization. And so you want to encourage people, not only in word, but also in deed, to come forward if they experience this kind of behavior in the workplace. I'm a big believer in training. A lot of employers think that their responsibility ends once they create their employee handbook and they give it to everybody and it has a sexual harassment policy. There it is, page 13. And that's important. It's important to have those policies. It's important that they be communicated to the employees. But if it's even more important and even more beneficial and even more helpful toward creating a harassment-free workplace if you train your employees on what that means. So that means telling them, this is what we consider harassment to be. So, these are examples of the kinds of things that we do not want to see or hear in our workplace. These, and if you do experience, if you do experience some harassment, this is how you report it. This is who you go to. This is what you say. And this is what will be done in response. So it's more than simply, here's the handbook, make sure you read it. You want to train people on how to spot harassment, how to stop harassment, how to recognize it when it occurs, how to report it, and how to eliminate it. I also recommend this. I put this in quotes because, as far as I know, I invented this. Harassment audits. Employers will often audit various aspects of their business. They'll audit their financial records, they'll audit their books, they'll audit their employees or monitor their employees' phone calls and so forth for purposes of training and customer satisfaction. I also encourage employers to do harassment audits. And what I mean by that is occasionally, once in a while, once a year, once every 6 months, doesn't have to be every other week, you give your employees a survey. You give them an anonymous survey and you say, are you experiencing any sexual harassment? Are you experiencing any inappropriate behavior, any inappropriate comments, any inappropriate images or jokes or unwelcome touching or sexual advances or propositions? Again, not with the idea of going on a witch hunt, but making sure that you know what's going on in your workplace, making sure that if things are going on that you're not aware of and that aren't appropriate for the workplace, that you can be proactive about it, you can address it, and you can stop it and snuff it out before it becomes a lawsuit, before it becomes a legal claim, before your employee leaves and sues you, and before you wind up as next week's headline in the newspaper. So that is the end of my formal presentation, but let me open it up for questions from anybody in the audience. Again, raise your hands high so I can.
Thanks for the great presentation. I love the idea about the audits. Could you give me some idea of 10 people that report an incident, how many of them, what percentage of them are real?
As opposed to a false accusation? Yeah, in my experience, it's about 8 out of 10. About 4 out of 5 harassment allegations are meritorious. I remember very early in my career, though, a woman came to me with a very, very believable, and you can't always tell at the beginning, in the first meeting, but I remember a woman came to my office. She worked at a department store, and she had a very credible aspect to her. I believed everything she said. I think that she made a very good presentation. And so I contacted the company and I started investigating the possibility of a legal claim. And the company's lawyer was somebody that I knew a little bit. And he said, Steve, let me sit down and meet with you about this. And so I went over to his office and he had all of these really passionate letters and sexually graphic greeting cards and pictures and other things that the the woman who came to see me, the alleged victim of the harassment, had sent to the harasser. And eventually it became painfully obvious that what had happened was that the woman had come on to her boss. He had rejected her, and her way of dealing with that rejection was, and she was convinced of it. I still believe that she believed it was true. Her way of dealing with that rejection was to convince herself that he had come on to her and that she had rejected him. So yeah, the false accusation does happen, but in my experience, it's comparatively rare, 10 or 20% of the time. Other questions? Yes, sir.
Hi. Is there a statute of limitation for bringing an allegation or a suit against someone?
Yes, there is. Excellent question. Another excellent question. There are both federal and state statutes of limitation. On the federal statute, the statute of limitation is 300 days from the date of the last illegal act or wrongful act. In the state of Ohio, statute of limitations is much longer. It's actually 6 years. But yeah, it can vary from state to state.
Are any of the false accusations a matter of perspective? And is sexual harassment a problem in any other place in the world, such as maybe Europe?
I'll answer the second question first. Yes, sexual harassment is a big problem in Europe. It's even a bigger problem in the developing world, the non-industrialized world. Sexual harassment is very pervasive in third world countries, unfortunately. And your first question, does the existence of a false accusation depend on perspective? Yes and no. I mean, there's a saying that everyone's entitled to their opinion, but you're not entitled to your own. Everyone's entitled to their own opinion, but they're not entitled to their own facts. I think whether or not, I think people can misperceive how their conduct is viewed by others. And we kind of talked about that before. But whether or not something is false is simply a matter of, whether it did in fact occur. What you so often encounter in these cases, though, is a situation where a supervisor and a subordinate were in a relationship for a period of time. And it looked to all the world like it was a consensual relationship, like it was welcome on the part of both parties. But then the relationship goes sour, which, believe it or not, happens from time to time. and then all of a sudden, the subordinate claims that it was never welcome to begin with, and then suddenly something that at one time looked like it was consensual, you now have a very hotly debated lawsuit over whether it was consensual or not.
Does anybody else have any questions? Okay, if we don't have any questions, let's give our speaker here a round of applause for sharing his wisdom with us.
Thank you very much. Thank you.
And I wanted to mention a class we're going to have Thursday night, Morgan's Raid. If you're not aware of that one, it's about a raid that a Confederate general made around, I think, Ohio, Indiana, and another northern state. And it went kind of unappreciated because it happened during the Battle of Gettysburg. But it's really going to be a fascinating class. So thank you very much for coming tonight. And thank you for your time.